today, and at this hour, I'm
All right,
hoping we're not
you are
entertaining
live.
anyone.
Okay, so we are live. It's 11 o'clock. We're back in Senate Economic Development, Housing, and General Affairs. We finished our work on the Sister State program. We currently have a 4-0-1 vote, and we're holding it open for Senator Cummings later this afternoon. And we're moving on to H704. Before we go on, and I'm about to be in front of my computer, Senator Harrison, were you questioning just the timeline of something getting out today and getting back to the House? Because we can always talk about rule suspensions. And that's a Senator Brock question for each of these things, but I don't think we need it at this point. And either council can tell us that or someone can ask Secretary Bloomer, sometime today.
I wasn't asking that question. I was trying to answer a question.
Okay, so at this point, if we get these bills out today, they shouldn't require a rule suspension to move through the process.
Right.
Shouldn't need it.
Okay,
I don't think.
I'll be sure to touch base with Secretary Bloomer this morning.
Just to
Damn.
be clear here, for the record, I'm Damon Leonard from the Office of Legislative Counsel. We will not take a rule suspension to get this bill through to the House by the end of the week. However, because there is a day before the Senate sends it over, it would reach the House at the end of the day on Friday.
Why?
So you're passing it out today, notice on Tuesday, second on Wednesday, third on Thursday,
So,
a day away on Friday. It then goes at the end of the legislative day after it passes, it goes to the House. They would need to take it up, suspend rules to take it up pending entrance on the notice calendar and concur, or they need to wait for the veto session, which I'm assuming will occur at this point.
the 17th and 18th, right?
Yes, and at that point, it will still be notice and they'll have to concur. There will be no time for amendments.
So, right, they would just
So
have.
that's just to be clear with the timeline we've got right now.
Right.
If there are no rule suspensions on the Senate side, the House will still need them. Unless they wait until the last day of the veto session to take action.
So Randy, we might ask you to do that just so that we can get it done.
It's the Sister State, I don't think there's a problem with that. Other bills where there might be.
Yeah, I'm hoping there won't be here. We've addressed the major concerns. So let us take a peek at this. Thank you for that clarification, Dave.
Yeah.
So that's gonna be true for any bill that gets passed out today in all the committees that we're looking at.
It's gonna depend from bill to bill. So this is its first time through the Senate. There are other bills where if you're concurring in the House, you just have a vote to concur and then you don't have to worry about the timing. But yeah, if you're sending it to the House and you expect them to have to review your changes to it,
Well, we need to, yeah, this is,
timing is tight at this point.
right. No, I think we're in pretty good shape on this one if we can get it out today.
And this is of course assuming we don't spill over into next week.
I think there's very strong likelihood we will spill into Tuesday and Wednesday next week. But hey, that's me, because I think the budget is fine, but the budget reflects all the policy that still hasn't passed. So, I mean, there's a lot in there that still has to go. So, yeah, I'm just trying to. So, Danny, why don't you take us through the draft as we have it? The last set of comments we got was from Bill Driscoll, and we have incorporated, and if we can answer all those concerns, that would be great.
Do you want me to go through the draft or Bill's concerns or?
Why don't we do both? We can do both as we go through, right?
Okay, so, want to ask Bill's forgiveness. I'm going to paraphrase. Please feel free to correct me.
I'll kick the chair.
So there were, as I read, Bill's email, there were three main concerns, that were raised. The first was what constitutes a specific job opening, and would a notice such as help wanted production floor or help wanted administrative offices be a specific notice and require salary ranges or not? So I think the answer to that comes down to whether the sign is advertising several different positions, not necessarily several jobs in the same position, but several different positions, or a single position. So specific means an explicit or exact job. So a general indication of help wanted, production floor, multiple jobs, or something along those lines would certainly be permissible, and then could have individual advertisements that people could view related to, for example, let's say senior machinist, maintenance technician, CNC operator, etc., that you might see on production floor. The difference would be if you have just one position that you call production floor. In that case, you would have to list the salary range. And this is not, so this is an instance where, you know, production staff is one position, and you don't have things like production staff 1, production staff 2, production staff 3. So that, I think that the language,
Draft should be okay.
I think if you interpret it in a reasonable manner, I do see the concern that there are these instances where you've got a general announcement out and it doesn't specify the job positions, and there are current concerns. But I think that if you're not advertising the specific job and it's just a general help wanted, and this could just be a sign that says help wanted and inquire with them.
Yeah, you don't need to.
And then when people come in to ask about the job, you could say something like, so we're hiring for a cashier.
The job range is blah.
Yeah, or we're just offering $15 an hour or $17 an hour, or whatever it is.
You can mention hourly rate when someone comes in.
But that's right, because it's an oral conversation. If you hand them a printed sheet, then
Don't put
you
anything
do
in
have
writing.
to.
Oh, gosh.
Right. Okay.
Damien,
That-
can you share your screen? Would that be okay, just so everyone watching can follow?
Sure, let me join the meeting.
McGowan, can you give Damien permission?
I think she may have already sent me the link, so I'll do that. While I'm doing that, I'll go on to the second question, as I understood it. And again, I invite Bill to clarify or correct me. But next, the testimony from AIV asked about the burden of proof for demonstrating that the salary changed because of factors beyond the employer's control. So this is an instance where an employer says offering $20 to $25 an hour, and then they end up paying, let's say, $18 or $28 an hour. And we've already in the bill identified that factors could include things like employee qualifications or labor market factors. So the burden of proof here is this is a complaint-driven process. So the initial burden of proof is on the person filing the complaint, whether that's a person filing a complaint through the Attorney General's office or filing a complaint on their own in court. They need to at least make a prima facie, which means first impression showing on the facts that there is a violation going on. After they've made that showing, the employer can then introduce evidence to show that there is a good faith business reason for why that occurred. Labor market factors, the employee's qualifications. So you applied for a journeyman position, you don't have a journeyman's license, so a master license, you're still apprenticing, we're paying you an apprentice's wage. Because we couldn't find journeymen to fill the position. The, if the employer makes, that factual showing, then it's up to the employee to introduce additional evidence to refute the employer. At the end of the day, it is a preponderance of the evidence standard. So whoever introduces under the weight of the admissible and credible evidence can show that they, you know, a majority of the evidence supports their side would prevail. But again, the initial showing has to be the employee. They have to show that there was a job advertised, that there was a salary range indicated, that the employer paid something outside of that salary range, and that on its face, from the information they have, there's nothing to indicate that there was a factor outside of the employer's control.
Right.
And it's the employer's response could be as simple as, we hired someone at $30 an hour because we were looking for someone with 5 years experience and someone with 15 years experience walked through the door.
And so
And we
we
wanted
offered
to
them
get
more.
them, so we offered them what the market dictates for someone with that level of experience.
And then someone who doesn't have a level of experience, the apprentice example is a good one. What about, for example, you're hiring someone as a server at a certain particular wage, and you don't think this person's going to be a very good server, but you're desperate to hire somebody, but they didn't smile and their personal reactions to the employer were, it's not what we really want, but we got to hire somebody. Could they hire at a lower wage? That pass that standard?
I think that gets to be a little bit closer case. You know, I think what you're looking for here is something where you can say, this is clearly outside the employer's control. I think appearance is always dangerous to base a wage on someone's appearance. But certainly lack of experience, bad reviews from former employer, things like that would be.
That person, typically, you just wouldn't hire that person.
Right, and that, in general, if you get a candidate who walks through the door and you don't think they're gonna be able to do the job. Unless you're desperate to fill the position.
But then once you fill a job with a person who you don't think is the right person, but you're paying them the wage that's called for in job applications, and it's an at-will employment, is there a danger in letting that person go for no reason whatsoever?
No,
That's a
you're
different-
still, yeah, this doesn't change the
That doesn't-
at-will standard.
Nothing
in the
here
state.
changes that.
So you're still free to terminate someone for any reason at all, assuming you don't have a contract and assuming it's not discriminatory or retaliatory for, you know, say reporting safety violation or something like that.
So I'm just cognizant of our times.
Yep.
Bill had a third one that we took and worked with.
And then can you also share your screen?
Yeah.
Yes.
Yeah, I'm actually looking at what I see as the only highlighted change on page 4.
And
And
then
I thought we were gonna say physical work location.
So
Yeah.
this is it, responding to Bill's last concern. So
Oh, okay, yeah. That was my concern as well.
I believe it's the.
Yeah,
That's what my, no, it's not.
so, yeah, the third question that I understood from Bill's testimony was the issue of reporting, so basically remote jobs that report to an office or location in Vermont. He raised questions about jobs that travel to multiple locations, including Vermont, jobs that are constantly on the road, but relate to a Vermont employer, and jobs for an employer that is headquartered in Vermont. So in other words, you've got an employer that's headquartered in Vermont, and then they have satellite offices or locations around the country. Is someone who, for example, manages one of those satellite locations, are they reporting to Vermont? And we did remove the word supervisor to address this in part.
Yep.
On further consideration, the change in the draft, which I am now putting up on the screen, was made to try to better address that. And it sounds like the chair may want additional changes. So it's either located in Vermont or performs work that is primarily for or on behalf of an office, predominantly for or on behalf of an office or work location in Vermont. And I think what I'm hearing is physically located in Vermont, Madam Chair, is that right?
Yeah,
I
I thought we
think-
had talked about that last time.
Is what
Yeah.
we said last
That's
time.
what we said before.
We did, and then we modified that. You'll notice that sentence in draft 2.2 does not track the sentence in draft 3.2. So
Oh,
if it is
Yeah.
located outside of Vermont, reports to an office or work site that is physically located in Vermont was what we had initially
So
proposed.
what would you propose to add here?
So I think you would say either physically located in Vermont for number one, or performs work that is predominantly for or on behalf of an office or work site that is physically located in Vermont.
We
No,
might do
I
it for
think-
both.
Yeah, that's what I just said.
yeah,
Oh, I thought it was an either or. Yeah, both is
Yeah.
good.
Not apply to them, just raise a question. For example, I recall a business that supervised, let's say, field investigators, insurance investigators. The headquarters was in Vermont. The investigations were performed outside of Vermont. Now, here when I get to that on behalf of an office or work location in Vermont, I still have that problem about supervision as to what that means.
Okay,
It's not clear.
I don't understand.
The boss is in Vermont, the job is being
that-
done outside of Vermont.
But it's a Vermont company, which is what we're hoping for, and it's a Vermont employee and.
But the employee is
Vermont
either working in
employees.
New York or New Jersey
But
or wherever.
But it's a Vermont employee. It just like,
Well,
you
you
know,
don't advertise in New York the job wages that you pay a Vermont employee. In New York City, you don't do that. It's misleading to that job
because it would be lower or higher.
because it would
or-
be lower.
So let's
Job
use Beta as an example, right? They actually fly people in from all over the country. So Randy, state your concern, Senator Brock, state your concern again that Beta is looking for an engineer nationally because they're located in Vermont. They have to advertise their salary when another company based in I don't know, Texas doesn't have to do that.
No, I'm talking specifically, the example that I mentioned is the company is in Vermont. The
Right.
job is in New York City. The work is in New York City. It is not in Vermont. The
then,
headquarters of the company is in Vermont, period. The job is not performed, doesn't do any work at all.
but then they can offer a competitive wage, and that could be a range that was proposed and.
Well, it may or may not be, but the point is, the job is not in Vermont, and so advertising the salary for a Vermont salary, a Vermont paid salary, that's not what they would do. They would, if the job,
It would
if
be,
we follow this in particular, the range that would be offered would be a New York City range.
but that doesn't,
Right,
that's
so,
fine.
so,
It doesn't say that that's
But
not
why-
possible.
But my point is, why? Why? What does that have anything to do with pay in Vermont? And why are we forcing someone to
We're not
advertise that?
saying that. We're not saying anywhere that it's Vermont pay. It's a company based in Vermont that is wanting to employ people wherever in Vermont or wherever that company has people. And they offer a range and a person accepts that job or they don't. And they could be in Timbuktu working for a Vermont company. I don't understand why that's a problem.
That's a problem if you have multiple places where people work and you are hiring them from the same location in Vermont, essentially from an ad that
But
may
you're-
appear in a national publication.
You're offering a range that you're offering and either people
The
accept it
range
or
may
they don't.
apply to some jobs, but not to all jobs.
It applies to that specific job.
In that specific location is one range, a range
think
that would
that's a red
apply in
herring.
Vermont is a second range, or ways that would apply in Wyoming could be a third one. range.
But I
it
think
could be a
that's,
very large range. is what would
Or it could be a
happen.
very large and
To
therefore
encompass
meaningless
all of
range.
that.
And so the point is, why would you advertise something that's meaningless?
I think you're assuming something here.
Oh, I am, and I'm sure, because I can think of a specific company and a specific set of events where this
That's fine,
situation
but
applies.
Then the company a Vermont company offers a job, a specific job at a wage range, no matter where they're offering it. If they're offering it in Hong Kong, they're cognizant of what the salaries are in Hong Kong. So they might offer a wage range that's suited Hong Kong. That is still a Vermont company. They're still offering that specific job at a wage range. That person accepts the job or not, and they work wherever they're gonna work. I don't see that as a problem either.
Well, I see it being as creating an advertisement that is meaningless. It's utterly meaningless.
So,
You have a-
two things. One, Damien, can you make me a co-host because Magali's Wi-Fi is out, and I don't want to. If something happens, I don't want to lose power to be helpful. And you're the only host now. And two, I'm hearing this. I think I need to be cognizant of time. And I guess Senator Brock, I would say that we have Vermont employers that are advertising for a nationally competitive salary. They want to be able to, attract the best folks, and they recognize that they will potentially have to pay people that way, whether they're in Vermont or Boston or New York. I can see how it's a little bit fuzzy. I don't know if anybody around the room would like to add to or detract from this concern, and how other states have done it.
I can add context on other states, but I know you have some witnesses who are interested in providing input too. So, whatever you prefer, Madam Chair.
Well, do you have context for other states that we appreciate hearing?
I can't tell you if you'll appreciate the information. So the other states, I went through the other states that had adopted salary transparency laws as of March yesterday. Some of the states are silent on this. If you're an employer in that state and you're hiring for a job from an office in that state or a location in that state, you have to pay or post the salary range, regardless of where the individual's working.
Yeah.
Other states like Maryland have gone the other route of just saying if the job is physically located in Maryland, you have to post it. There's no requirement for any other jobs. So if the job is fully remote, they're not required to post. If the job is at another location that is not physically located, you do not have to post. So those are
Those are the two.
those are the two approaches that other states have essentially taken at this point. Many states are just silent on this issue, and so even in their regulations, to the extent they've been adopted so far, there's no addressing this question of remote work. And I believe that there were some comments about potential questions that have come up in some of the states on that. I am not familiar with those questions, but I can tell you just from the statute and regulations, we kind of have this two-pronged approach. One, if you're an employer located in a state, you post it for everything. That's sort of the one extreme. Two, you only post it for physically located. And I think three is trying to find the balance here, identifying remote work more clearly, which clearly there is debate over whether this is a helpful effort or not. And I can't speak for the final decision there.
I think this is helpful and I think this is flexible. And what we're really trying to get at is best practices that are now pretty clear that people post range of salary. And I think that what we're trying to do is give Vermont employers the opportunity to post ranges, no matter where their employees are employed, but it's still controlled by a Vermont-owned company that's physically located in Vermont, and it's controlling what salaries it's offering. I don't see that it's a problem where they live or where they live or work. It's, for me, this protects and, this is strong support for a Vermont company to do the right thing. I don't see this as a challenge.
The company can do this on its own.
That's correct.
I mean, we're requiring the company to do it. If it's going to be a challenge to get this bill through the process, I would compromise and focus on folks who are in Vermont, because it's the Vermont workers who we want to protect the most.
I want, our business is economic development. I think we want to support employers and employees.
Or I'm just, I don't know where we're gonna go if.
I think we've made a compromise here that works. I think it works for me. Does it work for you, Bill?
So,
Okay.
Bill Driscoll, Association Issues of Vermont. I think the highlighted change that was made certainly does narrow that provision to a large degree. However, it doesn't, we haven't addressed the concern about basically traveling jobs that include travel and work in Vermont. Because this is not just Vermont-based companies, this is any company that hires somebody to do work in Vermont. So
Or a Vermont company
yes.
where they work. I mean, so we're trying to be.
So the travel
Damien?
question.
Sorry,
It's
I'm gonna
not-
interrupt, because we are gonna move on with Michelle and Michael's limited time. Damien, are you around at like 12:15 or so if? Okay,
I am,
sorry.
so, I'm available, yes.
Okay. I'd invite Carrie and Bill to go outside with Damien to draft language that finds this balance. If you'd like to, otherwise we're just gonna have to return to this issue when we're done with cannabis. And I would actually say we should be moving these bills by 1. I know you wanna
Yes.
wait for Anne, but things are, we can't leave anything to chance, so.
Fight today.
I mean, I would take stuff up to the secretary's office.
Yeah. I'm
So-
gonna need to look out myself on that.
Yeah, I will.
Okay, well, she's not here, remember, her Wi-Fi is not working, but we'll text her and we'll figure it out. But maybe Megan can help, we'll figure that out, but we need to move things quickly.
Okay, I just want to say, I think we're very close. I think we've moved a ways, and I think we're close. I never
Okay.
got an email.
Damien, in terms of flexibility, can I or Magali email you when we're ready to have you back sometime between 12:15 and 12:30? Okay,
Just, I'm gonna leave the meeting and you will be the host.
great.
So,
Copies, printed copies of the cannabis bill, all right?
Did we get a new draft?
Yeah,
I guess we did. If you're.
well, Macaulay sent me.
Thanks, Damien.
you're welcome.
Is that-
We'll work on something.
Okay, great.
Yep.
Thanks. And Carrie, can you join us?
There's compromise.
I think there's plenty of room for compromise here. This is not that difficult.
I don't know about that.
Okay, so we still have a quorum, so let's get Michelle in the witness chair. Michelle, I think I let you share. Let me know if I need to do something else.
And you still need to let me share my screen.
Did I just do it? It's been a long time since I've managed a Zoom meeting. Great.
I can't find copies, but
Where did you just have it?
I did it to the ledge.
Okay, then somebody's put them on.
No, they're not on the table, but Golly sent us a link that has all of the documents. 10, 17.
Well, aren't they just on our webpage?
Yeah, so,
Okay.
but I like
This,
to have it. Yeah.
the underlined one that you had directed me to do last week. I had sent that. Whatever the last day that I can't.
Friday? Was it
Maybe
Friday?
it was Friday, yeah, so it should be already. on
So you haven't sent a new draft?
No,
Okay, so it's the draft under 612 then from Friday.
right, so, so you should have, so for the record, Michelle Childs, Office of Legislative Counsel, you should have draft 2.2 amendment, committee amendment to H 612. This should all look very familiar to you and things that I went over with you on Friday. I'm just going to show you this. The outstanding issue is around setbacks, land use, things like that, which is why Michael is here to talk to you about that
Okay.
as to whether or not you want to include anything on that in this amendment, or you could also, because this still has 2 more committee stops to make, you could also do an amendment on the floor.
Right, which I think sounds like a probably good idea. The Ledge website is very slow and I can't even open it.
So I'm just gonna walk through here, and again, I think it's all gonna sound very familiar, You're probably tired of hearing me talk
No,
about
not
it,
at all,
but,
not at all.
so first instance of amendment is striking out section 2. That was the section in the House version having to do with amending the definition of controlling with regard to we think about people who are allowed to have licenses. And remember, there's been the issue that the board has been having and working with the FBI around getting criminal background checks. And the board thought they had something that would work for the FBI. That has since changed since the House changed that. So they had asked and you had approved for that section to be deleted. The second instance of amendment is amending, creating a new section 2A on advertising. And you'll see it is striking the language in subdivision 4 there on lines 19 and 20 around the prohibition on offering a prize, award, or inducement for purchasing a product.
Right?
The third instance of amendment, this is starting the Senate Health and Welfare amendments that I went over with you on Friday that they voted on. And so the third instance of amendment is pertaining to the rulemaking of the board around the medical use endorsements. Page 3, the fourth instance of amendment, this is the issue around whether or not, so currently, patients do not have to have a certain length of time established with their healthcare provider prior to the provider signing the medical verification form. This is instituting a new requirement for under 21. If they are on the registry, is that they have to have had at least a 3-month relationship with that medical care provider, and they have to do an in-person visit with a physical examination for the under 21. It would stay the same for 21 and over.
Same as it is currently for 20.
Yep.
Yeah, got it.
So fifth instance of amendment is adding a new section 11A, and this is on reporting with regard to the medical program. Change from the previous version was that you'll see at the top of page 5, subsection A, Cannabis Control Board is to work in consultation with a number of groups on these reporting requirements. You asked that the Green Mountain Patients Alliance and the Cannabis Retailers Association be added, which they have been to subsection A, and there's no other changes to that section with regard to the reports. The sixth instance of amendment, this relates to the farm buildings and the cultivators using certain buildings and creating an exemption around certain fire and safety requirements. And that language is changed because the Fire Safety Division, in talking with the board, just needed a little bit of tweaks to the language there. So, but that was a proposal that was in the House version. You've just tweaked the language a little bit. The seventh instance of amendment is pertaining to the Cannabis Business Development Fund and the Cannabis Social Equity Working Group. I went over that on Friday. There's no changes to that.
Are you here to help us?
I'm just on something. It seems like you need it.
Yeah, I think we do. And Macaulay's internet is out.
Yeah. Okay. You're still live.
Thank you.
We know.
Yes,
That's live.
so Megan, I'm host. I think it's like voting sheets and printouts and things. So committee, if you could email Megan with anything you need printed or something like that, I think she can help.
I think trying to get somebody to join us.
I do have the voting sheets.
Is that what you're trying to do, Megan? Okay,
But
Megan
do
is
you
trying to get
Do you
somebody
need
to
something
join us.
posted, copies made?
I did want a copy of this bill and then
What bill is
there's
it?
something.
And I can't get online, so clearly the internet in this building is having some
The
challenges.
State House doesn't like Mondays.
It's 6/12.
I can send it to her when.
Oh, perfect.
Okay.
Thank you.
So the eighth instance of amendment is striking out section 16 and 17, which is in the House version, are the provisions on establishing the cannabis cultivation district and the setbacks. And so those have been removed here. And then Michael O'Grady is going to be talking to you about another proposal for your consideration as to whether or not it's something that you want to include in this underlying amendment, or whether or not there's still, the jury's still out on these issues.
I mean, as an interim measure, those setbacks.
well, it depends on where you land. I think there's a
Right,
lot.
it's, it's different scenarios and options for us to look at. Does anybody have an issue with this language?
No,
Yeah, I've got a couple of questions.
Okay,
We can go back to the first item. Striking out section 2.7 its entirety. Could you again tell me what it is we're striking out?
I'm sorry, so in the first instance of amendment?
First instance of amendment, yes.
There's a definition of controls or controlling in terms of people's participation in the market because Vermont limits folks to only one license
Mhm.
or one type of each license so that you can't be kind of like the McDonald's of cannabis retailers. And so a lot of it hinges around how the definition of controlling works.
Mhm.
And one of the requirements in the underlying law that you passed in 2020 was that people who are applying for a license have to have a complete criminal history background check. Those can only be obtained from the FBI. The Cannabis Control Board is not a law enforcement agency, so they don't have automatic access to that database, and they have to work things out with the FBI to be able to get those records. And I would leave it to James to talk to you about kind of some of their struggles in being able to meet that. It's a number of other states have kind of been in the same boat around willingness of the FBI to be sharing that information with these control boards. And so the proposal that was in the House version was something that they thought would maybe be the ticket. And that some other states were trying, and then my understanding is since that legislation originally passed in the House, that the scenario has changed, and they don't think
They're
that
not able to get.
that language
Yeah,
won't do the trick.
And so my question is there any substitution in terms of the kind of criminal record check for states or otherwise that exists in order to ensure that we're not licensing criminals?
I think that would not
Okay,
come from me in terms of my understanding is they're doing everything they can. They certainly have access to everything that BCIC here in Vermont can provide.
That
But
should cover most of it.
that'll cover
But-
what happened
but
in Vermont.
Right,
Those are
but the
arriving
issue
Vermont
around
yesterday.
how they're getting access to those, whatever, I think you
I
need
think,
to
I
speak
think
to
we should
James
have to
about.
hear from the commissioner. To really better understand what this means. And then the other question that I had. Find it. One of the. Yeah, it's regarding the working group in section 7. And it refers to the Cannabis Business Development Fund uses provided in 7 BSA 987. Can you just walk the system, what those uses are?
Sure, I can pop up the statute for you, so you can take a look at it.
Oh, you are wonderful.
I don't know that I am yet, because I don't know what I'm doing, so.
I'll go see if stuff printed.
So, Jolly's internet went out.
Wendy, I would, okay.
But,
Ron is here to.
Yeah.
oh, sorry.
No, I know. I would just let Ron handle stuff outside of the committee room so we can keep going.
We are.
Okay.
I asked Ron,
Great.
forgot to count the three. Yes.
So here you go. So there's a chapter in the Cannabis Social Equity Programs. The money currently flows through ACCD. And they have established a program using funds from the Cannabis Business Development Fund, which you are generally, like last year, the appropriation that is in the underlying amendment is the same as it was before. And it's moving money from the Cannabis Regulation Fund where all the taxes and the fees and things go. And moves $500,000 from that fund into the Cannabis Business Development Fund. And then ACCD administers that for the purpose of providing financial assistance, loans, grants, and outreach to social equity applicants.
So $500,000.
Right, and the study that's contemplated here is to look at whether or not there should be a designated set percentage that you capture from all of the excise tax money that would be going into the business development funding.
Everything in the comprehensive. But if you tell me what you want, I'll. do that
Six,
too.
I think Michelle can tell you what we want.
I'll send it to you,
Yeah,
but also, grades, that's brand new.
okay, but maybe Michael shared his screen too. Like you wanted to join, and that's good.
Give me just a moment to catch up with you.
I assume you want me to share screen?
Please.
Do you think? And somehow Delia's in on this too, so.
Right,
So you're right.
Yeah,
So as Michelle referenced,
we're not live.
we're live, it says we're live,
Let's do that.
cause I think Keisha is controlling the computer.
I mean, it
that
says
is-
YouTube on my screen. I can pass hosting ability over
Ron,
to Ron. And I don't know how, if it says YouTube and we haven't been live, I think Magali's watching us, so.
I tried to log in, my computer's restarting, so I'm gonna need a moment, but,
I'm making room 27 co-host, and then I'll make you host, or I'll just stay co-host, honestly.
on is. Right.
Right, so Senator Ron Hinsdale, if you're able to make Ron Wild the co-host.
I don't have Ron separately in my participant list. I have State House Room 27.
So it would be,
Joining in a
if you
moment.
go to invite,
Ron is joining in a sec.
Okay.
Computer decided to read this one.
That's okay, mine did the same.
And we haven't gone off live, I don't think.
no, you never went off live.
Okay. People have let me know who are watching.
6:30, Senator, 6:31.
Oh, 6:12,
6.
you need a pad.
So do you see the place where you're able to invite?
Sure. Am I inviting like Ron's email address?
Yeah,
R Wild,
R Wild,
Mm-hmm.
R,
Gee. It's working.
Senator.
How many copies of which bill? Of which version?
Well, the MOG, the one that says MOG, it's draft 1.1. I don't know if it's a separate. is that
It's
good?
Michael Brady's draft and.
That's what we
sent it
haven't
to
seen
Ron.
before, and I think that would be the most helpful, so 4 copies.
Is that on it's on our website? I
It's,
believe.
yeah, it's 4 pages.
are you having luck with that or no?
I'm opening the link now.
Oh, you got it.
Yeah, we could just print 4 or 5 copies. of it.
Not the thing I sent. Ron,
Yeah, he's doing the MOG.
I just want to make sure it's not.
Okay,
Should I start?
Yes,
let's start.
Time is
precious here.
As Michelle referenced earlier, section 16 and 17, as they passed the House in page 612, would have allowed municipalities, depending on where and what they had done, established setbacks within certain parameters from the plant canopy to the property boundary or to roadway. I was asked, I got an email from the chair through the chair of the board to remove those sections and to replace them with these sections that are in front of you. I do have some questions about this language.
The first new section 16 would be amending that section of law related to land use standards and regulation of cultivation. There would be in the current list of regulatory benefits that cultivators, outdoor cultivators would receive, the right to farm, the rebuttable presumption against the nuisance would be struck. And that seems a little counterintuitive to me. I don't know why that's being offered, but that was in the list of things to do. So there would no longer be any nuisance protection for rebuttable presumption of nuisance protection for cannabis cultivators, outdoor cannabis cultivators.
So can
So
I
in
set
two-
the stage a little bit? So
Yeah, that's,
we've been exploring another option with Mike O'Grady, that had to do with rulemaking and putting it in the hands of Cannabis Control Board. Pepper offered this alternative. And, we now have counsel telling us that this is a pretty big change. So that's why I wanted to put both on the table without making a decision for anybody. One is the proposal that the Cannabis Control Board would like, and one is what on Friday we thought might be the best, Thursday or Friday, we thought might be the best path forward to put this decision in the hands of the Cannabis Control Board.
okay, I think this is a little much, but I think that what we asked for was for the Cannabis Control Board with stakeholders to.
We're gonna get to that. We're gonna get. To
Okay, so we haven't
That's the
gotten,
other proposal.
maybe we should,
No, it's just,
Well,
it's in this language.
there's
But why don't you let me get through?
yeah, why don't you
the
finish?
amendment. And so the next language would set a 50-foot setback from the roadway or property boundary to a plant canopy for outdoor cultivators. But it is, there's section 17, which would make that only applicable to new outdoor cannabis cultivators, and it would be repealed within 1 year. So frankly, that setback's not going to apply to that many outdoor cannabis cultivators. And it will only apply for a year. But in that time period, under section 18, the board is going to report, is directed to report to you regarding the siting and licensing of outdoor cannabis cultivation. They'll summarize the current impact of outdoor cultivation on local municipalities, summarize the impact of various siting requirements on existing licensed outdoor cultivators, address whether and how to authorize municipalities to establish local cultivation districts, and recommend whether local cannabis control commissions should be granted additional authority to regulate outdoor cannabis cultivators. They will consult with the league, cannabis cultivators, and other stakeholders in developing this report. As part of the report, they will address the impact of modifying the law governing cannabis advertising. I don't really know what that last part is about. It wasn't something I was involved in, but it was part of the list of things to add to the language.
So I'm okay with this report. I think that this is what we had wanted and what we discussed. Is that that we would look at density, what was appropriate in municipalities with compact development, compact, growth centers and compact centers. I don't understand, and so for an interim measure, we would have a 50-foot setback. That's not very much in a compact dense downtown, but anyway. So I'm not sure.
And the 50-foot setback is for any new applications.
I agree, but a new application in downtown, wherever, it's not very much.
Right, but it's just for a year also. I think this is a compromise between
Right.
having towns regulate it and towns not be able to regulate it. And knowing that the assumption was that most of the cultivation would be indoors, but it turns out that most of the cultivation is out of doors.
I got
So
that,
I think,
but 50, I mean,
no, and I don't
50
think
isn't very
50
much.
feet is that, but
So
it's
I'm
more
okay,
than 25.
I'm okay with that. I'm okay with 1 year thing while we get this report. I'm not sure I'm okay with the repealing the farming piece.
I also want to note that if the report comes back on time, you're probably gonna go through 2 license cycles before anything from the report gets implemented.
So we may have to extend this 50-foot interim.
Yes, that's basically what I think. At some point, you might have to revisit this interim setback because you're probably not gonna have the recommendations of this report and implemented for 2, maybe even 3 license reviews.
So that's kind of a little concerning if we're talking about downtowns, because I still think the 50 feet is inadequate.
But that's something you can address next year.
Yeah,
It's
when we
just,
have a little
I just
more time.
wanted to put that, understand.
No, that's a good point. The interim may be a little bit longer.
Right.
But so I'm okay. I don't know, how does everybody else feel? I think the report is good and I think the interim is
I
at
think
least workable.
it's a reasonable compromise.
Does the House have a thought too? The House okay with this? Cause it's gonna need to be okay, cause we're gonna not have time.
And I have been communicating as the stuff has been moving. I mean, this is the first time I'm really looking at the words on the page right now, but the frame is what was discussed leading up to this.
Okay,
So is that mostly yes?
That's I'll give you a mostly yes for right now. Are you planning on voting this out right now?
We
we're
need
voting
to,
it out by
or
12:15.
in its day. we have-
Gabrielle, you have a,
Yeah, thanks for recognizing me. Gabrielle Molina, Downs Rockley Martin. Since the report, and I apologize to Councilor Brady who hasn't gotten to that part yet, but the report also asked about advertising. So I would ask that the Cannabis Retailers Association be included in the consultation group since it is about advertising as well. The report.
okay, so who do we say with stakeholders?
Does say cannabis cultivators.
That's different from the.
Cannabis Retail
Oh, I'm sorry,
Association, so
retailers.
just-
Cannabis Retailers Association of Vermont.
Or could you just say cannabis cultivators and cannabis retailers instead of calling out a specific organization?
Yeah,
We
it
already
calls
did
out
that in
Vermont League
the
of Cities and Towns for obvious reasons, but since it's about advertising, that is, it affects the retailers
Okay.
most of all.
Okay, I'm fine with that.
This particular change, is there any substantial opposition to it that you're aware of?
I'm not
To
there.
changes to advertising?
No, this is what the report is gonna look at. The Cannabis Control Board is gonna look at advertising. That's just why Gabrielle is asking us to include the retailers.
Medical Society would also need to.
So
be
Jill, would
included.
you like to identify yourself for the record?
Jill Sudhoff-Garren for the Vermont Medical Society. We also have concerns about any changes to advertising regulations, so we'd like to be part of this group.
That sounds reasonable.
Right.
In terms of the setback issue, 50-foot issue is.
Okay, let's deal with
Where-
one at a time. This is the report. Let me go to the interim in a sec.
Alright,
So let's finish on the report. Is everybody included that needs to be included on the report? Great, then let's move back to the interim measures, because I think Randy had a comment on the interim measures.
so right, the interim is this 50-foot or property boundary or edge of highway, but it is only for those new outdoor cannabis cultivation license issued after July 1, 2024, and it's repealed in 1 year, July 2025. That is something you obviously know how to amend the text of repeals if you think you need more time. So that's just one of the 5
That's
measures.
straightforward from that standpoint, but have we heard any particular objections to making this change?
I have not.
We've been asking all the players, and I think we're okay at the moment. So I think if we're okay with the report and the interim measures, what I'm hearing from council is that perhaps we would want to extend the interim measures for 2 years rather than 1. Is that, no?
This is board's recommendation, I'm just.
Okay,
flagging
fine,
it.
we can always deal with it next year.
Yeah, we can move it next year. further
Okay,
out.
let's go,
And then the last is the rebuttable presumption.
right, and so,
Against nuisance for outdoor cultivation. I was told to remove this, I don't know why it's being removed.
well, okay, let's hear, the Cannabis Control Board would like to have this removed, but this is a concern and I think a flag for us, so. And I'm not sure we're the committee that fully appreciates the implications And I think that's why we have counsel already here to have us fully appreciate the implications, because it's got big implications. So, Pepper, introduce yourself and tell us why you want this.
Sure, and for the record, James Pepper, Chair of the Cannabis Control Board. I'm also joined by my General Counsel, Gabe Gilman. To say that I want this, I think is a somewhat of a misrepresentation. I think what we're talking about here is cannabis cultivation is not, outdoor cultivation is not agriculture. Over the years, certain rights to farm exceptions have been granted to outdoor cultivators to make it more like farming, agriculture. One that was added last year is this very language that you're seeing, this rebuttable presumption that outdoor cultivation is not a nuisance in the same way other agricultural activities are not a nuisance. This was added last year as a way to kind of make sure that people weren't getting kind of sued over odor issues on a case-by-case basis, is my understanding. I can't understand why this language was put in the bill other than that last year. What we're saying just overall as a concept, which is kind of what I see as the compromise between the House and the Senate positions, which is eliminate the setbacks from applying retroactively to the existing cultivators. We don't understand how many people will be impacted by this.
And the report will deal with that.
Put a 1-year pause on this situation that happened from repeating itself in the next year while this report is being generated. And that's that 50-foot kind of only applicable to new cultivators. And then this, by removing this presumption, this rebuttable presumption, what you're saying is an outdoor cultivator is on the same playing field as any other landowner that's making a nuisance to their neighbors or purportedly impacting their neighbors. And that the neighbors can sue under the nuisance law, which is well established. It exists. It's existed for hundreds of years. It's been developed for case by case law, and it just puts kind of the neighbor. It gives them the ability on a case by case basis to say, no, this cultivation of cannabis is interrupting the kind of enjoyment of my property, and then the court will evaluate kind of both sides and determine this on a case by case basis, as opposed to setting a 50-foot setback or a 100-foot setback. Allowing municipality to do that, which honestly probably doesn't even solve the odor problem.
Oh, no.
Right.
That's.
So it's kind of a blunt force instrument to deal with something that's more of a kind of case by case nuanced situation that, a court could look at both sides and determine kind of who's.
So, unlike farming, this would allow neighbors, people affected, to
bring a nuisance.
Can I just interject?
Yeah.
The right to farm does not prohibit someone from bringing a nuisance claim. The right to farm changes the standard that needs to be shown in order to bring a nuisance claim. You have to show that it does not, it has a substantial adverse effect on health, safety, or welfare, or has a noxious and significant interference with the use and enjoyment of neighboring property. Not just that it interferes your use and enjoyment of your property, that it has that heightened standard. It doesn't prohibit a nuisance claim from being brought. People think that, but it does not.
Okay, so if we left this language in, people could still make a nuisance claim.
At a higher standard.
But a higher standard's applied. It has to have a noxious odor or.
Right. It has to have a substantial adverse effect on health, safety, or welfare, or has a noxious and significant interference with the use and enjoyment of the neighboring properties.
Have there been any claims that anyone is aware of as a result of the language being used?
I'm not aware of any.
The more I hear from Pepper and hear the discussion, the more uncomfortable I am with striking this, because we don't only allow farmers that so they can farm. It's because it's costly to go to court, and this is not the stage where they make a ton of money. Far more than farmers. So it would be exposing them to a costly new liability. And if people do take advantage of this, it can get really expensive for somebody to hire a lawyer.
But what I understand from council is that this doesn't actually change that ability. Neighbors can sue with or without this, it's just a higher, what it would protect. I think everybody to have a higher standard for before you bring a nuisance. So I mean, I don't. We need
But
to strike it.
agriculture gets that rebuttable, I think we're agreeing, agriculture gets that rebuttable presumption, so the bar is a little higher when you're suing,
Exactly.
you know.
So I would do this, I think it'll cost. Yes, I agree. So I would hope we could remove the striking of section 5.
Okay, can I say something? So I am in support of the striking. So cannabis and agriculture are similar, but not the same. And cannabis has much less of a history. So my understanding of the rebuttable presumption is that it was done that way. It provided protection for farms when houses were developed next to farms. So you didn't want people moving into a farm and then being upset, or moving next to a farm and being upset. This is the case. In this case, the cannabis is coming into the neighborhood, so it's a different situation. So I think it's more fair at this point to take that rebuttable presumption, which has only existed for a year,
Yes.
away, and then just and look at this more in the upcoming year, so that we can find a better balance, because cannabis isn't exactly the same as agriculture. Its history is different. And we've decided not to give tools to the towns. So the towns are losing something in this compromise.
So how about we add this as one of the things, leave it in, and then add it as one of the things for the Cannabis Control Board to review?
Yes, and I think it is. It's fundamental for them to review.
Right, but I would leave it in as law now, and leave it in and see and have it reviewed as one of the report items.
I would not leave it in, because the longer you leave it in, the more that folks will come to rely on it, and it will be seen as something that they lose later. They've only had it for a year. So, and I guess I guess that was the question about it. Has anyone used it? If it hasn't been used, I think this is a better time to remove it, because it may have been too much. It may give them too much of a head start on
Give the board
lawsuits.
a year to look at.
Yes,
That's what
Yes.
this is.
yes, and I really
No, if you mean by striking it.
Yes, but because then the courts, because it is a very individualized thing. In some situations, 50 feet could be plenty, but in other situations, it wouldn't, and we need to look at much more than setbacks. I mean, the whole issue is how to live together in harmony, right? So, I think it's important to delete this now, knowing that we can always come back to get it, once we have a bigger picture, because it's evolving.
So.
We don't have
I'm
a lot of time. We can do one of two things. Hear from, a grower for a couple minutes, if we can get Jeffrey to come in to see if they want to raise a concern and haven't had a chance to. I'm sensing it's kind of 2 to 2, and I don't want to speak for Anne. But I'm willing to give this to, to the two that are concerned. I think we just have to sort of make a decision. I get the concern. I get that it's new. So we could hear from somebody about things we're not thinking of.
I don't growers person in the room, and I'm not sure there's one listening. And if there is one listening, I don't know who you'd communicate to, but you could communicate to Ron Wild. Or to Matt Byron.
If anybody from the Growers Association is listening, Jeffrey has my cell phone number, please text me.
Okay, because we have like 7 or 10 minutes because this clock runs fast. But the other thought would be, I would be okay leaving it in only if we add it as one of the things for the Cannabis Control Board to review in the report.
They certainly should be reviewing it. When you say, okay,
But you
leave
say
it in,
certainly
do you
doesn't.
mean, no, I agree it needs to be in there, but I just want to be clear. When you say leave it in, you mean leave the strikeout in?
Yes,
Okay.
I'm only okay with that if we would also ask the Cannabis Control Board to look and make a recommendation, because it sounds like they are making this recommendation, but maybe we added.
I can add it specifically if you would like.
I mean, one path forward. Unless we hear from a grower who feels very strongly it should stay in. I think it should stay in. I think we should unstrike it.
One side of the story, and again, I realize we're in a hurry, and that's when we make
Yeah.
mistakes.
Well, we had many years of it not being there too, so, I mean, of it. Oh, do we have a response?
Growers Association is emailing Mr. Wild for link.
Okay, we have Growers Association's gonna give us their input.
We can,
Thank you,
we can give them about 3 minutes to respond, but I think it's fair. I don't, both ways, it's a big decision, so I don't want them to feel like they didn't get a chance to speak their piece before we vote.
Well, this makes it easier to complain. The other raises a slightly higher bar for
Where did the strikeout come from? Who initiated the strikeout?
the cannabis control.
Well, I should just say, in trying to find a path forward for this bill, which does a number of things beyond the citing issues and a number of very important things, I'm trying to see what would be acceptable in this, there's no time for a conference committee on any of this.
No.
Right, so I'm just trying to figure out, it sounds to me like the House is very adamant that they want those mandatory setbacks applied retroactively. That there may be a path forward if neighbors on an individual case by case basis could have some relief that isn't at such a high bar.
The setbacks don't apply retroactively, they apply prospectively to each license renewal. That is not a retroactive application at all.
But
Now-
but the
Oh, I was
Well-
just gonna say, now give CCB the opportunity when they look at any renewal to take into consideration setbacks and some rulemaking there. Right?
Cause the licenses are so short.
it's my understanding that at the time of renewal, if a town has, in the interim, applied the setback or passed the setback, that setback will apply to the existing cultivation site. And that could have the impact of zoning someone out of existence or having us to not renew a license because there's no, 50 feet has made it so that this plot is no longer usable.
And that's a dynamic that happens with farming. You change the buffer width, you change the setbacks, you change. Farmers have to comply with it, they lose the ability to farm that property, it happens.
I'm trying to understand. I thought we did apply the 50-foot setback only to new applications in our language and not to renewals. If we can't make that distinction, then
It does make.
Okay. Okay. That was important to me.
It's a house pass version, the way that is set up. That if that were to become law and the town were to enact a 50-foot setback or a 100-foot setback, which is allowed, that would apply at renewal to the existing licensees.
So how are we doing with Jeffrey?
He's trying to get into the meeting. I'm still not host, so can
Oh.
Senator Ram let him in?
Your co-host and you can invite people. Yeah, there should be no reason you're having trouble.
Co-host.
Doesn't say that I am. I don't see anyone trying.
Oh, you're Ron. You're not State House. Okay.
He's R Wild at ledge.state.
Right. I had made State House co-host. So can I really want to clarify that. Does the CCB have the flexibility to only apply the 50-foot setback to new applications? I did not want to retroactively apply that. That was not my intent.
It does not apply to any license that's previously been issued. Even on renewal, it will only apply
to new
outdoor cannabis cultivation licenses issued after July 1, 2024.
Okay, Ron, are you now co-host?
I am trying to communicate with Jeffrey.
Oh, okay.
Because I have to give.
Has Jeffrey emailed Ron?
He did, but he doesn't have the link, so. try to get it to-
So who needs to be gone back?
Oh, we're fine, we're just waiting.
He
Ron is-
emailed Megan trying to get in,
But now he's emailed you, I hope.
no, but I mean. just-
Okay, Ron.
Okay, just sent it.
Okay, Jeffrey now hopefully has links. And Jeffrey, we hope you'll join us. And
There he is, I'm just hitting his application.
great, thank you so much. Good morning, Jeffrey. Good morning, Jeffrey.
Good morning. Can everyone hear me okay?
Yes, and you're hip to what we're discussing.
I am. Terrific. Thanks for the invitation. Appreciate everyone's
Okay,
time.
about 3 minutes. We're sadly very tight on time. But if you could respond to the proposal to strike number 5 on page 2 of Michael O'Grady's draft amendment.
Absolutely. I mean, we would ask, and I've been hearing, just to share everything, and I know I need to be brief. I've been hearing everything that you guys have been discussing this morning. Thank you for bringing this back up. Clearly, a lot of work was done over the weekend. We would simply ask, I mean, again, I just want to stress, I want to reinforce, we welcome this argument, this conversation. We think it is of value. We just simply think from a procedural perspective, there's not enough time. We would ask you to consider just folding this into the report. And clearly, we would like to be a part of that reporting body as well. If not BGA, then a member of our coalition, being the principal drivers of this policy over the X number of years. And I just want to, oh, go ahead. Sorry.
No, so can you just clarify, are you asking to unstrike this language and put the review of it into the report? Or are you asking to keep the language struck and also keep it in the report?
Not struck. Keep F5 in statute as of right now, and we would ask that be part of the assessment. We believe that requires that due process. And I'd like to take part on this committee. Keep in mind that though, and we recognize cannabis likely will not be designated as agriculture until there's some sort of federal change. That being said, just keep in the back of your minds in this conversation, albeit it's the end of the conversation, that hemp is included. Okay, so these individuals who are maybe beholden to these proposed rules and you know, different siting requirements, hemp is not a part of this. So we can have theoretically a grower growing even more hemp plants in an area where they are not allowed to grow high THC. I just want to impart that on the committee. I think it's important. Hemp can oftentimes smell more, can be more pervasive than high THC cannabis. I think that's important to consider when having this conversation.
Okay.
Okay.
So
thank you.
I think we've heard adequately from all sides. I imagine we're still at a bit of a 2-2 kind of leaning in that direction. And people have, you know, there have been people who've had to kind of give up things that they wanted on both sides with the setback provisions from the House. So we have to take their voice into account. I really hear what Senator Harrison said on trying to really find a true compromise, and that has only been in place for a year. So if we're at a 2-2 impasse, I would still give it to Senator Harrison and Senator Brock and take out the rebuttable presumption for the next year while the CCB looks at this, and especially since the CCB thought that might be a way to empower the municipalities a little more without killing existing permitted growers.
So you're proposing that we do strike it, but that we add it as to be reviewed in the on page 4 of what they're reviewing. and that we have cannabis cultivators here in the list, Jeffrey.
You want Vermont Medical Society.
We're adding,
Yes.
it sounds like we're adding the Vermont Growers Association and the Medical Society and the retailers.
Is the Cannabis Equity Coalition in there? I think that was the request.
They're not here.
Okay. I think, I can't tell, Jeffrey, if you felt like you wanted Cannabis Equity Coalition instead of the growers, or?
That would be preferable. We would
Okay.
ask if others are going to be explicitly listed, that we would be considered to be explicitly listed as well, just because we are largely the architects behind a lot of this language.
Okay, and we being the Cannabis Equity Coalition.
Correct, exactly. Thank you for clarifying, Chair.
Yeah.
Okay.
Okay, so, should we,
Let's vote.
well, I'm sure it's that, simple. What would you like to do, Keisha? Should we wait for, Mike to do a new draft so that we put them together?
While Mike
well-
is drafting, if he feels he can multitask, I would just let Representative Byron sort of say a last few words, since this might get to them on Friday. And we're just hoping that this works for the time being.
No, thank you, Madam Chair. For the record, Representative Macaron, Vice Chair, Government Operations, Military Affairs in the House, reporter and sponsor itself.
Mike.
I think that this strikes a good balance. I
It's gonna be
understand we're very time pressed. Removing that language, moving the study for a 1-year period. I feel comfortable moving forward with that.
Okay, so that was, yeah,
Thank
my
I
compromise.
just wanted, and thank you all for the time and the energy and effort.
Okay,
So
Thank
it
you.
sounds like pending Mike O'Grady's edits, we can still vote if people are comfortable with that.
and it will be on Michelle's amendment, so it'll come back to us incorporated in Michelle's amendment. I don't know what draft number that will be.
I don't either.
And they've left. How,
So, but I mean, I think we all understand. So nothing changed in Michelle's, and we landed where we did with O'Grady. So we can take is wrong.
no, it's gonna be on this one. So it's gonna be, so it'll be either 3.2 or 2.3.
3 or 3.
It'll either be, yeah, so,
So do we all understand what we'll be voting for?
yeah, we're
I
Voting.
believe I do.
We're voting the amendment as presented by Michelle, plus Mike O'Grady's additional amendment, which will be incorporated into Michelle's as the 9th or 10th instance of amendment, I can't remember which. We will be keeping the struck language in number 5 and adding a number of people to the on page 4, the report that the Cannabis Control Board will be instigating, and we're adding the Medical Society, the cannabis retailers, cannabis growers, and
The Equity Coalition.
the Equity Coalition. And in addition to those interested parties, we will be adding a review of the rebuttable presumption. That is my understanding. Do I have it?
That was good. Yeah.
Okay, so I would propose that we, pending the exact number of the draft from Michelle, which will either be 3.2 or 2.3, not clear, or something altogether different. That we, I would make a motion,
Yes.
I would make a motion to pass out Michelle Child's next draft of this amendment
Whatever it may be.
favorably.
Okay, so I'll call the roll.
Perfect.
Senator Brock,
Yes.
Senator Clarkson,
Yes.
we'll wait on Senator Cummings. Senator Harrison is a yes. Senator Ron Hinsdale.
Yes. And thank you,
Great.
committee, for sticking with it.
4-0 so far.
And Randy, you offered to report it?
No.
Just check.
Senator
okay.
Harrison, Senator Clarkson, either of you willing to? I mean, I will just get up and do it if nobody else wants to, but I'd be happy if someone else would.
Report cannabis last year, you wanna take a stab at
What the heck?
it? Go for it.
Sure.
Okay,
Okay.
Harrison's on it.
Yay, thank you, Senator Harrison.
We'll talk.
Yeah, no, it's a strong Wyndham County tradition.
That's true.
That's true.
Becca would be proud of you.
Okay. Great. I think then let's invite Damien back.
Magali
will
has
have-
emailed him to come back.
Okay, Jeffrey, thank you so much
Thanks,
for being
Jeffrey.
so on it. We're very impressed.
Thanks for the committee's discussion. We appreciate it. Take care.
Thank you. And you solved the question I had, was whether you were a GEO or a J, and you're properly spelled GEO.
Well, that is a big relief.
That was enough to keep me up at night. Have fun, and thank you so much for your help.
Have a
And
good day.
Jill, Gabrielle, thank you, and Gabe, and yeah, thank you so much. This was good. And Matt's already departed.
Yeah, I just looked up and he was gone, so.
All good. Thank you, Ron, for navigating all this.
Are we
Very
going
helpful.
offline?
No, we're staying on live and waiting for Damien.
So I will finish the record of action once I have a draft number.
Yeah,
Mhm.
we will, and they're coming back in
Oh,
5 minutes.
I've just been writing it.
Oh,
Yeah,
that's
writing
fine.
it.
Okay.
But
So
they-
we'll just fill in the draft number when they come
That's
in.
fine.
They'll be back.
I'll just scan it and send the system.
Okay.
Sure.
They confirm they're coming
Okay.
back in a few minutes.
They'll be
Why don't
back
we
in
get-
5 minutes.
Can we get offline just real? Is that
Can we
okay?
go offline?
Just offline? I just wanna eat.
Oh,
I need to
okay.
eat on.
For that
But-
purpose,
but you-
yes.
Okay.
So I still don't have control of the.
Oh,
So
maybe we-
application, he doesn't have control of the meeting.
If you can't do it, I'll
I
just
can't do it as kind of a.
deal with it.
Do it as opposed to.
You know, Damien's gonna be here in a minute.
All right,
So
can I just go into the, I'm gonna
Yeah.
go in the hall.
Yes,
Okay, or in.
I eat all the time off, but I get it.
I'm sorry, I don't like it.
We could also go
Okay.
off video. There's no, if
That's-
we're live, but
Oh,
we're
yeah.
not discussing policy. You are
Has to hear.
going off video.
You'll make me host, I will
Can you
end the
make,
live stream, or you can end the live stream from where you are, but
can you make Ron co-host?
no, host.
Host, primary host.
Sure. You're able to stay for the next however long, Ron?
Will be another,
Yeah.
I can't do more than 15 minutes because I have a 1 o'clock and I gotta
Right.
eat lunch.
Yeah.
Okay, great. So Ron's, I just didn't want to lose anybody else.